Hello and welcome to a series of 3 videos on tribunals and alternative dispute resolutions. These videos have been created for the OCR A-level specification, although they might still be relevant for the AQA or EdXL A-level specification. If you wish to follow this video more effectively, I recommend that you click on the icon on the top right-hand corner of this video and download the handout that goes with it so that you can take some notes as you go along, and also so that you can do the activities in the handout. As I said, there will be 3 videos on this series, and the first one is going to explain what is meant by alternative dispute resolutions. This would be assessed in the OCR specification as an 8-mark or a 10-mark question, depending whether you're being assessed this year or next year. And the second video will look at how employment tribunals work. Again, that will be assessed as an 8-mark question. And the final video is going to look at the advantages and disadvantages of using the civil courts and ADR, which in the exam would be a 12-mark question. So this handout also have a section with key terms, and I recommend that at the end of each series of videos you go back and make sure that you understand each of those topics. And you should find it beneficial to use the textbook for the OCR specification if you're doing the OCR exam, and this content is for chapter 4. So if you haven't bought the textbook, you can get it on Amazon on a digital version, and the link for it is on the description of this video below. So let's get started with our first objective, and that is to explain and describe what it is to have an alternative dispute resolution, or ADR. So an alternative dispute resolution refers to a way of resolving a dispute between parties that doesn't involve going to court. So that means we don't go to a judge, we don't sue someone, we try to find a way of fixing the problem and solving the dispute without involving the courts. An ADR refers to 4 different ways of solving a dispute. The first one is negotiation. I seem to have missed the N in negotiation. Mediation, conciliation, and arbitration. And that's what we're going to be looking at in this video. So let's look at the very first type of ADR, which is negotiation. And negotiation is the least formal and easiest way to solve a dispute. I say easiest way because in theory, and that is meant to be the easiest way. Whether that works in practice, that's a different story. But in theory, this is the easiest way. And it simply means that parties try to solve the problem amongst themselves. So most parties of a dispute will initially try to negotiate a settlement before further action is taken. So a settlement is an agreement and often involves some sort of payment so that the parties find a way of solving their own dispute without involving the courts. And so you would have heard in the news something called as an out-of-court settlement, and that often happens through the negotiation stage. But sometimes negotiations doesn't have to just be the parties themselves. Sometimes they will engage solicitors, and this will be something that will happen before a civil action is taken. And in many cases, as soon as solicitors are involved and the solicitors talk to each other, the dispute is resolved before it gets to the court date. The problem with negotiation, however, is that it is not suitable in every situation. So, for example, if the parties are really angry at each other, they can't see eye to eye. So imagine, for example, you start up a business with a friend and then you fall out, and there's a lot of emotional baggage and an inability to talk and engage with each other. Negotiation will be ineffective in those situations, and after negotiating you might still end up in court. And that is one of the issues that happens throughout many of the alternative dispute resolutions methods. Now let's take a look at mediation. And mediation is when an independent third party will meet with the parties of a dispute and try to get them to reach a settlement. So instead of the parties doing it on their own, they have a neutral third person that serves them, helps them to communicate with each other, helps them make communication clear, and tries to get them to find their own solution. The mediator, however, will not make suggestions, and they will instead facilitate discussions to the parties and try to get them to make decisions for themselves. And mediation can take many forms. For example, it could be a mini trial that could be held between the parties, and the mediator will do a lot of the things that a judge would do, except they do not have any legal standing, they don't have to have legal training, and their decisions will not be binding. Mediation is often used in family disputes, and the reason for that is that it tends to be very informal. Mediator can make suggestions on things that a court might not be able to solve. Emotions often run very high when there are family disputes, and so a mediator who often has training in counseling will be able to help parties to solve their own disputes. In fact, divorcing couples are often encouraged to use mediation rather than the courts, simply because it seemed to be more appropriate for families to solve their dispute through the mediator, rather than having the stress and the anxiety of going through a formal court process. Also, mediators are often used by local councils to help solve neighborhood disputes, and this is also the case because emotions tend to be very high. Parties themselves might be able to come to decisions that the court wouldn't be able to enforce, and they are better suited when they can talk things out between themselves and come to a solution. Now, if you got an exam question on this topic, you would be asked to explain in detail. So you can make a lot of the points that I have put here on the screen for you. Make sure that you don't just regurgitate what I've just told you. If you make any of those points, you need to make sure that you explain them fully and that you demonstrate that you know how it works and that you understand it. Now, let's take a look at conciliation. Conciliation is similar to mediation, except for the fact that the conciliator will play a more active role in trying to solve the dispute. So instead of just listening and trying to get the parties to find their own solution, the conciliation, who's still a neutral party, will actively try to get them to come to an agreement. So they will often offer suggestions and try to get the parties to reach a settlement. So sometimes the conciliation will meet the parties separately and go between the parties with suggestions to a problem. The conciliation process ends up with something called a non-binding opinion. And this is the same as for mediation and negotiation. What that means is that any agreement that is reached through this process is not legally binding. So if one of the parties decides not to do it, there is no legal recourse to force them to do it, and you might end up having to sue them anyway. So one of the big drawbacks of this process is that after a long, painstaking process that could be stressful and painful, you might still end up going to court. But it has its advantages because it has the opportunity of solving a dispute before it gets to court. This form of ADR is often useful to solve dispute between companies, and they often use conciliation to assess the strength of their case. So if they want to know how likely they are to win, they might engage in conciliation at first to see if they have a good case and if it's worth taking to court. Oftentimes they will look at their case and think, actually, this is not worth it, so I am not going to take it to court. But many of the times they will be better prepared for court after being through the conciliation process. So let's look at the fourth type of alternative dispute resolution, which is arbitration. And arbitration is the most formal type of ADR. And in many ways, it is similar to court in the sense that you have an independent third party that makes a decision on the case. They don't just advise, they don't just get the parties to try to come in an agreement amongst themselves. They actually tell parties what to do. They make a decision. But unlike court, but like other types of ADR, parties have to agree to have their dispute decided through the arbitration process. And this agreement can either take place before a dispute arises, or it can take place after a dispute arises. And arbitration has become quite popular among different businesses and trade unions because they use this to settle their disputes. And in fact, many contracts include something called the Scott v. Avery clause. And the Scott v. Avery clause is essentially a term in the contract where parties agree to give up the right to go to court, and they agree to have their dispute decided by an independent arbitrator. And this agreement is actually quite significant because the Arbitration Act of 1996 states that courts will normally refuse to deal with any issue if the parties have agreed to go to arbitration. There are, of course, some exceptions to this, like a claim that is very small and it can be easily dealt in the small tract claim in the county court. But for the most part, once the parties have decided to have their dispute decided by an arbitrator, this means that they lose their right to go to court. And you might be wondering, why would parties do that? Well, arbitration has a number of advantages, and one of the main advantages is that it gives parties maximum choice. They can choose a number of things that they wouldn't necessarily be able to choose through the court system. So they can choose their arbitrator, they can choose how many arbitrators listen to the dispute, they can choose whether the arbitrator is a lawyer or an expert in the subject, they can even choose the format the arbitration takes place. So let's look at some of the options that parties have. So first of all, they can choose the time. Let's say that they decided to go through a hearing. They can set a time and a date that is mutually convenient to all the parties. That doesn't necessarily happen in court. If you sue someone, you might get a hearing date that is not convenient, but it is not very easy to change because the court schedule is quite busy, and you also have to take into account the judge and a number of other parties. So the flexibility is simply not there. So if you need flexibility because you have other things going on, arbitration is able to provide more flexibility than the court would. The other thing is they can choose the number of arbitrators. In the court, you might be restricted, depending on which court you go, to one judge or three judges, whereas with arbitration, you can have one single arbitrator. You could have a panel. Perhaps you want to have a balanced opinion. You may want to have a representative body for a number of reasons, so a panel might be better. And the important thing is you can choose this. The other thing you can choose is the format. Some arbitration could be quite formal, so it could be like a hearing involving lawyers and witnesses, and it will be very similar to going to court. Or you could have something called a paper arbitration, and a paper arbitration is when most of the disputes and the evidence is presented through documents. It might be sent electronically, or it might be sent in different formats, and the arbitrator makes a decision based on that evidence without the need to having a formal hearing and hearing witnesses in a very formal setting like a court. As I said before, the arbitrator might be a lawyer, but they could also be an expert in the area of the dispute. So think about an example. Let's say you are Google and you have a dispute with another company because they have stolen your idea for a particular functionality of an app that you are developing. You go to court and suddenly you get a judge who can barely use email, and I'm exaggerating here, but in that sense, you have to invest on expert witnesses that will explain the technology, that you will have to then hope the judge actually understands the technology and makes a decision with full understanding. But if you have somebody who's already an expert, you are saving time and money in explaining things, and you have a better chance of being understood and then therefore getting a solution that is suitable to your needs. One thing that is very key about arbitration, which is very different to other forms of ADR, is that the decision is made by the arbitration is final. And in some cases, they will make an award. And an award could be a payment, or it could be a direction for parties to do something in order to solve the dispute. And this award, it is binding and final. What does this mean? This means that if the parties do not do what the arbitrator tells them, then they can take them to court and have the court enforce the award. Now, this is very different from taking somebody to court to have the dispute resolved, because as we discussed, once they've agreed to have arbitration, they don't have the right to have a judge make the decision. But once a decision has been made, they can go to court and enforce that decision. With other forms of ADR, if they don't like what the conciliator or the mediator helped them achieve, they can simply ignore it and then go to court to have a judge listen to the whole situation and make a decision. But with arbitration, they can only go to court to have the outcome enforced. Now, the award has very limited options for appeal. It can be challenged in the Queen's Bench Divisional Court on a point of law, or if it's thought that there has been some serious irregularity, like there has been some fraud in the type of the arbitrator, or there has been some sort of misconduct. So as you can see, the threshold for appealing an award through the arbitration process is actually quite high. In addition to this, you also have to have leave of appeal. And in many ways, this is much harder than an appeal would be in a civil court. So to summarize, ADR stands for Alternative Dispute Resolution, and it refers to ways of solving disputes between parties without going to court. They range from the least formal to the most formal: negotiation, mediation, conciliation, and arbitration. Negotiation is when parties try to solve their own dispute on their own and reach a non-binding decision. Mediation is when a neutral third party helps parties reach their own non-binding decision but does not actively offer a solution. Conciliation is when a neutral third party actively helps parties reach an agreement by offering a non-binding opinion. And finally, arbitration is when a neutral third party makes a legally binding decision which can be enforced by the courts. If you have enjoyed this video, please feel free to press on the subscribe button so you can get the latest updates and the latest videos. Thank you very much. Bye bye.